to do is just really break down MedMal firstly, just from a structural point of view, the way the modern health practice is actually working, very much focused on the SME side, and in particular talk about what their insurance arrangements are. Now, this isn't going to challenge experienced brokers, but I think it's very useful for a little revisit, because health is definitely one of the huge growth industries in Australia. If you look at the last, and particularly in Victoria, you look at the state budget or the federal budget, there's just so much money being put into health, and it's growing all the time. And in particular, Australia is starting to become a destination for a lot of Asian business people to come here and have their families treated. So there's a lot happening in the space. I'm going to quickly talk about the structure of health practices, then I'm going to talk about who pays for malpractice, negligence claims, disciplinary inquiry and general liability. I'm going to talk about the typical insurance portfolio for a health practice, and also revisit the mandatory insurance requirements, which people tend to forget about. That's all part of the APRA licensing regime, and then give you an example as to how contribution claims between the practice and the doctor work. So this should only take about 15 minutes. Then I'm going to go through a worked claim example. Now, hopefully you can all see that diagram. This is pretty much the standard way a health practice is set up. Now, I'm obviously not talking about a public hospital, or even particularly a large private hospital, but they generally follow this structure. You in the middle have the owner there, which is usually a corporate trustee. The reason why is that doctors for years have favoured a management structure where the taxation is all at the unit beneficiary stage, and so you have a pass-through model in the trust. The trust itself usually doesn't pay any tax, but it needs to hold assets. Now, what does the corporate trustee usually own? Usually own the health records system, usually manage all of the expenses in terms of staff, and then have a responsibility for maintaining the premises, and in particular making those premises compliant. But one of the key things about the medical space is that the work is done by the health practitioner, and you see on that block there I've put the provider number. Now, one feature of health is that it is the individual and the individual provider number that is the link to the payment, right? And you see on that diagram where the money comes from. It either comes out of our own pockets as patients, or it comes from a private health insurer, or it comes out of Medicare, our public health system. And what ties it together is the individual provider number. And that's fundamental to our system. Make sure that we avoid fraud, the genuineness of the treatment that's being done, and also the particular code that covers the rebate that we receive out of our insurers. So this is different to the kind of normal commercial structure that we experience as employees of like your insurance brokers. You're employed by somebody. Your employer is going to be vicariously liable for all your negligent actions. Well, that's not. It is the exact opposite in the health sphere. In the health sphere, you are starting from the proposition that this is an individual responsibility done by independent contractors, who are the people with the special care and skill that are liable for anything that happens. Right? So the normal rule about vicarious liability just doesn't happen in the health sector. You actually start from the exact opposite. So how does that impact on the insurance arrangements? Well, going at the bottom line on what is really the easy stuff at the health practitioner level, you really have what's I call traditional med-mal. Now, allied health is basically structured the same way. It is cover for your individual responsibility in relation to negligence actions, disciplinary inquiries when you need defence costs to cover a prosecution by your disciplinary board, and obviously any personal injury you've caused by reason of the exercise of your profession. So that's been the same way pretty much for about 120 years. Now, for the people, and Gary's going to talk about the structure about medical defence organisations, and also the hold that the MDOs really have over individual doctors, and to a lesser extent allied health. But it's been that way for a long time, so much so that it used to be that doctors basically band together, paid a premium into a trust fund, and then they just had a trustee that would pay all the claims. And that was the model right up until 1996, until there was a few unpopular cases involving deep sleep therapy, a case called Bailey, in the Supreme Court of New South Wales, where they exercised their discretion to deny compensation to a number of patients that had died in psych hospitals as a result of deep sleep therapy. Insurance Act's been changed. Now MDOs need to have a claims-made insurance core, and they've also got a high-cost claims scheme, but that's not really what we're here to talk about today. It's just that at the health practitioner level, it's very difficult to get that sector to move, because it's been that way for a very long time. But we're seeing a lot of developments in relation to the ownership structure. Now, We've all probably been to Medical One. Anyone treated by any of the chains? I know I am. My family goes to Medical One now. It's actually fantastic. And there's a lot of increasing change. And actually, a friend of mine is a HR manager at Ramsay Health. I have a lot of discussions about this. They really do not want doctors as employees, right? They really want them as independent contractors because as a general rule, they're a nightmare. They don't want to be told what to do. They're the ones who've obviously got the care and skills, so they don't like people in a practice dictating to them as to what the scope of their professional responsibility is, and they just want to be left alone, but they want the admin taken off their hands. And it's a pretty difficult model to discharge. So even at these massive corporate chain level, you're not finding doctors being engaged as employees, you're finding them as independent contractors. And so what does the owner really need? Well, obviously they're responsible for the premises, so they need public liability insurance, and they need their own professional indemnity insurance, but then in particular, they really need cyber nowadays. Now, I'm not going to talk a lot about it, but there's a national health database called My Health coming up where all of us are going to be asked to sign an authority so that all of our records go into a national health system and can be accessed by any practitioner that we access anywhere around the country. But you can only imagine now what the potential is for risk, data breach, mandatory reporting requirements, and also the damage that can flow from that. So I think cyber, it might become mandatory, but it's definitely going to become needed. And in particular, it is needed because the very thing it provides that is of use, I can say, from cyber claims, is the expertise from IT consultants who actually really know what they're doing to stop a data breach or to stop a malware attack and actually get the records back up and accessible. So that's what they really need. Now, the confusing part that creates a lot of confusion, which I'm going to try and unpack for you today, is, well, how does the professional indemnity of the corporate practice of the owner actually apply when you've got this traditional med-mal core for the individual, right? So we'll get on to that. Okay, so let's start by asking, all right, well, who pays for claims? Usually it's the health practitioner, right? They are independent contractors and the usual rules of vicarious liability do not apply. So it's the health practitioner that's liable for their own errors. Now the practice can be liable for their errors. We're going to talk about what those errors are, and each party needs their own insurance. And then contribution is sorted out on the usual basis. The courts apply rules of what I call relative culpability, which is the extent you've caused the problem and your culpability for that problem. And this is expressed as a percentage. Okay. Now, I'm going to come back to a worked example, but the key thing about this is that insofar as the practice, I'll probably go back a little bit, insofar as the practice on this slide is actually employing receptionists, nursing staff, and also putting in processes about record keeping and the like, if those practices and procedures fall down, then that's what the corporate entity is going to be responsible for. Right? But almost always, I've never personally had a situation where the practice owner has been solely responsible, but I've certainly had situations where the practice owner has found out that the health practitioner didn't have any insurance because their registration had actually been cancelled a year before and they worked as a locum. Now, does anyone want to fashion a guess as to what happens in those circumstances? Right? The practice ends up copping it. All right, in the old days, we used to be able to say, oh, but we're not vicariously liable for these doctors. They're independent contractors. We're not responsible for their actions. It's just getting harder and harder to run that argument in the courts in this day and age, and the courts will come up with a number of ways to get around it. So it is absolutely critical for this practice that they actually make sure that these people are registered because it's a condition of their registration that they've got to provide evidence of insurance. And if they don't do that, well, they are going to be liable and they will want their PI policy to respond. Now, disciplinary inquiries. For years, it came as a big shock to a number of doctors that their employer didn't actually cover them when the medical board or the dental board came knocking. And also, most health practitioners have a deep distrust of their employer's behaviour if they become the subject of a regulatory inquiry. So all of them want their own cover. They want to get their own lawyer in their back pocket to be able to help them through that inquiry. So they need defence costs for representation, but also at the corporate level, right? Don't let your clients who might be directors of the corporate trustee think that they don't need disciplinary inquiry cost cover. They do. right? As the owner of an entity that's providing health services, they can be the subject of disciplinary inquiries by AHPRA for defective processes, employee error or data breach. Now this is whether they're registered or not, right? The regulator doesn't often do it, but they do have power to reach over and get to directors even though they may not be registered health practitioners themselves. Now, very quickly, I'll just skip through this. This really shouldn't trouble you too much. But general liability insurance, slip and trips, is the responsibility of the practice owner. Health practitioners are entitled to an indemnity on the structure that I gave you before because it's the practice owner that's responsible for the premises, and also the med-mal policies exclude general liability claims. What is the difference between a professional indemnity claim and a general liability claim? It is obviously the professional indemnity is the use of your special skill from years of training. The general duty is something that anyone can do. Classic example in aged care, the orderlies that change the sheets, who don't need any qualifications whatsoever to be an orderly. That's a general duty claim. The nurses who've gone through 4 years of training and understand how the frequency of changing sheets and avoiding bed sores and all of that sort of stuff are using a special skill. Okay, so it's possibly a little bit repetitive, but let's just have a look at the typical insurance portfolio. For the practitioner, it's not complicated. Traditional med-mal for doctors or PI for allied health practitioners, which is basically the same cover, right? You want liability for negligent actions and you want defence cost cover for disciplinary actions. That's what they're after. Now, all cover must meet the AHPRA mandatory insurance requirements, and I'll give you a table, and there's obviously, I've set that table out in the paper as well, which is on your chair. But for the health practice, 4 things: general liability, PI including disciplinary cover, cyber data breach, and then My Health and My Health developments, which I've discussed earlier. All right, now just quickly, when the national law came in 2010, they followed the model that was put in by the Building Act in 1993 that tied an obligation to have insurance to your registration. A lot of people still forget about this, but you can get on the AHPRA website and you can see what the minimum insurance requirements are. As an example, for chiropractic, minimum cover of $10 million for any single claim and run-off cover for 7 years after ceasing practice. Nursing and midwifery, you've got to have run-off cover, but there's no specified limit. Pharmacy, minimum $20 million for any single claim, and you have to organise run-off cover over the next 7 years. Now, it hasn't been a problem yet that I've encountered, but obviously people underwriting schemes and organisations need to warrant that the cover that they're providing, or they're certainly asked by the clients to warrant that the cover they're providing meets the mandatory standards set by AHPRA. Okay, now moving quickly on to how contribution claims work. Employees are entitled to indemnity, and that's usually nurses and admin staff. Health practitioners, independent contractors are not, and the common arrangement that the health practitioner must organise their own insurance and normal rights of contribution apply, and usually liability or the bulk of rests with the health practitioner. So let's go through a worked example of that. Let's say I'm a doctor and I own the Good Health practice in St Kilda. The practice has a doctor, a psych nurse and a physio, all who work as independent contractors. Now, all practitioners, including myself, are registered with AHPRA. Sorry, I missed out the H there. Leggett employs the receptionist and the support staff, or really the Good Health practice does. And none of the support staff are registered nurses. And Gribben's the physio. He's fond of treating patients with heat lamps. I know Chloe is laughing because this is an adaptation of a real scenario that's just happened, a practice that Leggett disapproves of, so much so that I've issued a written direction to Gribben not to have any staff assist with the use of heat lamps. And Gary, being the normal person he is, told me to F off. And at the end of a very busy day, has a receptionist set up a patient for an hour-long heat lamp treatment. Now, this is controversial as most heat lamp treatments last half an hour, and most physios think that heat lamps are unnecessary. I've expanded on this in the paper a bit more, but physios usually say they should be treated with ice, not with heat. But a lot of physios have borrowed the Chinese medicine theory and say that heat works even on inflammation. The nurse sets the heat lamp at 45 degrees Celsius rather than 35 degrees Celsius as Gribben has directed. After 1 hour, the skin is red, but the patient is in no pain and Gribben discharges her. Now, this is actually real. I didn't know that this could actually happen, but the patient then presented to emergency that afternoon and then was diagnosed with very significant subcutaneous burns that then presented a very, very significant scar to her leg. Now it's expected that the quantum is going to be $250,000. Okay, letter of demand arrives at the Good Health Practice claiming $250,000. This is pretty basic, but let's go through. What's going to happen next? What's Good Health Practice going to do? Notify. Good Health Practice, definitely going to notify. What else am I going to do? That's right, I'm going to only stamp it on Gribbo's forehead and say, you go and notify your own insurer as well. Okay, now then what's going to happen between the insurers? Pardon? They're going to duke it out. Okay, and how do you reckon, so they're going to duke it out, how do you reckon the contribution would end up? In Gribben's favour?
As in he'd have majority share.
The majority share, well that's not really in his favour. That's him getting the just desserts he's always deserved for his life of reckless conduct. Depends. What do you reckon, Chloe? What apportionment do you want to give me?
It's hard to say, but if 35 degrees was not going to cause any burns to this patient, it's all on the nurse.
Yeah, that's right. It's all on the nurse. So what would you give it at?
Well,
He's breached my written direction not to use staff for this ridiculous practice.
Has he renewed his policy?
Yeah, he's all paid up, but there'll be an exclusion in there. If you're underwriting Gribbo, you'd put in some exclusions, wouldn't you, mate? Now, what do you reckon? Give me a punt.
more, I'd put 50-50.
50-50. All right, it's fucking like a true claims manager. All right, anyone else want to give me, what do you reckon, Sarah, given it was partly your file, but we didn't have the, what do you reckon? What are you going to put it at? Cam, what do you reckon?
And I take instructions from Chloe.
So you're at 50-50 right now. Okay. Anyone else want to have a punt? Chris Varcoli, what do you reckon?
Do you want to answer it?
Yeah.
I'll probably go 80-20.
80 to Gribbo? All right. Okay. Anyone else want to go a bit higher? You didn't follow my written direction. God. I know, you're all traumatised from Eurovision over the weekend. I know I am. I reckon contribution would be at 90-10. A couple of things that would really go to that is that leaving someone under a heat lamp for an hour really is a bit of a, you're not going to get any evidence to say that a heat lamp treatment really should go for an hour. But then also it's the risk in relation to it and delegating to someone who's specifically been told not to delegate to. It means that, but then you've got a clear error by an employee of the practice. I thought it would come out at 90-10, right? But who knows? But the main point about this is why the practice needs their own PI, right? It's to cover exactly this sort of a problem. Okay, so key messages, then I'll hand over to the wonderful Gary Gribben, and then we've got drinks and nibbles thereafter, after you've enjoyed your, how many CPD points, Chris? One point. God. You'd learn more watching Eurovision. I know. Focus on the individual that is providing the treatment when analysing liability exposure. All right, that's the way this sector of the market works. Certainly different in financial lines. Understand the difference between independent contractors and employees. It matters a great deal when organising insurance for health practices. Cyber to protect data breaches, I think will become mandatory eventually. So see if you can get ahead of the curve and get your clients buying up, and keep up to date with the mandatory insurance requirements on the APRA website.
Let me start with the market, because there are a number of different, importantly distinguishable segments in the medical malpractice environment. Firstly, medical malpractitioners. $350 million of base premium, 102,000 registered medical practitioners in Australia, of whom 88,000 are active in their profession. Allied health practitioners generate a pool of approximately $40 million of base premium, slightly more than 100,000 practitioners involved. Private hospitals are a significant force in the provision of healthcare and in the medical malpractice segment. Much more difficult to get a line on the base premium generated, but $40 to $50 million would probably cover it. There are some concentration elements that make it difficult to identify quite what the true base premium is. There are practice and entity covers in abundance It may surprise you to learn that some $40 million of premium is now generated out of that specific segment. There are, of course, the public hospitals and government health services in the states and territories. Those entities are insured via the VMIA here in Victoria, Treasury managed funds and equivalent organisations in other states. They are not for you a viable segment. Now, medical practitioners historically have carried medical indemnity insurance, a specific subset of professional indemnity or of medical malpractice. Historically, medical defence organisations dominated the area. They sought to establish a club environment in which they were ruled by councils of medicos, where they provided significant medico-legal advice and support. In 2003, the world changed. We saw the advent of the Medical Indemnity, Prudential Supervision and Product Standards Act, which mandated insurance rather than mutuals as the organisation required to provide such protection. In consequence, the major medical defence organisations formed wholly owned subsidiaries: Avant, MDA National, MEGA, Medical Indemnity Group Australia in South Australia, and MIPS. Each of them trades nationally. They enjoy tremendously high rates of retention. Average retention across the sector is 98% historically. We'd all die for that as brokers and insurers. So the inertia that characterises general insurance as a widespread phenomenon is at its most pungent here in medical defence, in medical indemnity. There is, however, on the horizon now a sole commercial insurer, TEGO. TEGO is a Berkshire Hathaway specialty insurance underwriting agency. They've entered into a long-term agreement between the organisations, as each of them is mature and not in any way naive here about the fact that it's going to take quite a great deal of effort to break the stranglehold that the traditional MDO insurers enjoy. You are therefore able to present individual doctors, specialists, proceduralists, or schemes, if you have access to any of them, to TEGO. Their premiums are indeed very competitive. They are at the margin 20% cheaper than the medical defence insurers, but have still not to this point moved beyond 1,500 practitioners. So they're there looking for business, and if you have access to doctors, then I'd certainly encourage you to contact Eric Lowenstein, their Managing Director, who's an excellent guy. His details are there. The area of allied health, of course, covers a multitude of health treatments, disciplines, and shonkies. At the top end of allied health is the regulated segment, those involving allied health professionals, people such as dentists. I hesitate to say this, but chiropractors. At the fringe, chiropractors, if they are extraordinarily doctrinaire and believe in the full doctrine of the chiropractic, are functioning lunatics who believe that every significant ill can be cured through chiropractic practice. Physios, psychologists, osteos. This is an area where each of those specialist practice areas, including Chinese medicine nowadays, are regulated by APRA and where there are specific occupational insurance requirements to protect patients. There is a huge range of unregulated health service providers. As Hamish mentioned, over 1,000 modalities are transacted by Prorisk. There are the usual suspects: massage. I particularly enjoy Reiki because I can stand here and I can heal you all. And I hope you're getting that very positive, health-giving vibe. If you're not, I can always practice my colour therapy on you. My socks, for example, are a form of colour therapy. Look lovingly upon them and concentrate, and most of the known diseases will be cured. I say most, but not all. So counselling, yoga, acupuncture, which I particularly enjoy. David needles me all the time. Of course, I'm a Richmond supporter and he's a North Melbourne supporter, so we won't talk about football today other than to say that Richmond won handsomely. Beauty, aesthetics, cosmetics present a particular range of problems. There are a wide range of activities here embracing some quite dangerous, potentially dangerous ablative laser treatments, non-ablative laser treatments, facials, dermal fillers, both permanent and non-permanent. Anyone who thinks that it's a good idea to have a permanent dermal filler inserted into any part of their body has me guessing at their sanity. To imagine that dermal fillers will not migrate is utterly astounding. So some very low risk treatments, some I think very high risk. All of them are available to you as brokers. In the professional area of allied health, I think you'll all be aware and understand that associations, professional associations, tend to be the predominant organiser and arranger of insurance programs for members. So you have the ADA program for dentists, you have the APA program for physiotherapists. Orthopods, osteos and others have their programs. To transact in those areas which are actively competed for by commercial insurers as well as by MDO insurers, and where brokers are a force, requires that you develop the appropriate knowledge and systems. We have in Australia 630 private hospitals, 33,000 chairs and beds. Increasingly an enormous amount of activity, health activity in private hospitals as well as public hospitals, is delivered in chairs as opposed to beds. 60,000 employees, 40% of all hospital treatments in Australia are conducted in the private sector. Nearly 60% of all surgical procedures are nowadays conducted in the private sector, many under contract with the federal government. Private hospitals constitutes a hugely concentrated area. Ramsay is the predominant supplier here in Australia and has extensive operations in France and in the United Kingdom nowadays. The Catholic Church, most notably through Cabrini and through St Vincent's in all states, has a very significant involvement in the provision of private hospital care. The Uniting Church has Epworth, probably the largest private hospital, certainly in Victoria, does everything except obstetrics. Healthscope, Healthcare, and in Queensland, Mater are also significant private hospital healthcare providers. Now, probably only 25% of the private hospital environment is contestable for you as brokers. Ramsay, of course, with its international operations, is not a client target for an SME broking business. It's very firmly in the hands of the multinationals. The Catholic Church private hospitals transact through CCI and probably always will. Clearly, if you're going to be involved in private hospitals, you need to understand the environment. You need a very, very clear understanding of what they need in terms of a complex holistic insurance program that incorporates medical malpractice amongst other covers. Then the practices and the entities, which, as I say, are nowadays contributing $40-odd million of pure premium. So it covers the liability of and the duty of care owed by medical-related establishments. We see a lot of clinics, super clinics. We see a lot of combined clinics nowadays, typically featuring a doctor, a a physio, maybe a chiro, maybe a psychologist. So people presenting at a centralised processing area known as reception. A particularly large claim with which I was involved a couple of years back involved a patient presenting at reception at a clinic, complaining of very severe chest pains, was asked to take a seat and wait a few minutes. Practice was busy, the receptionist forgot, no doctor appeared. An hour later the man was discovered sitting there dead, which resulted, of course, predictably, in a very substantial claim against the practice. As David has pointed out, breach of privacy now has become a particular concern in all health establishments. The maintenance, if not ownership of records, rests with the clinics, with the entities, the practice, and any disclosure of that information will, as you all understand, constitute a very serious breach of privacy, dealing as it does with very sensitive private information. There are 44,000 GP businesses in Australia. There are nearly 2,000 diagnostic and imaging businesses in Australia, some 356 pathology businesses. Each of those requires insurance in its own right. The annual growth rate of GP businesses is just under 3% over the period 13 to 18. Over 4% for imaging, because that's one of the lovely things about medicine. Supply and demand are not economic constraints or variables that observe traditional economic indices in Australia. As the number of scanning machines and MRIs increased, as supply quadrupled and then increased tenfold, what happened to prices? They went up, not down. And that seems to be the way at the moment. As quickly as pathology practices and radiology practices are built, prices increase to fill the available wallets. This is an area actively transacted by a wide range of insurers, Prorisk one of them. Historically, Vero, CGU have always been involved, and the MDO insurers too, because of the conjunction of medical indemnity insurance and the ownership via trusts and the use of corporate trustees are also very active in the area. That then is the environment. What I want to finish off with is a look at three particularly interesting med-mal cases. First, AII Limited and GEO. GEO was the private operator of a New South Wales prison. Part of the contract with the government made clear the requirement for GEO to provide health services, particularly psychological and counselling services to inmates. A New South Wales government agency provided the direct healthcare, more broad-ranging medical services. GEO held a med-mal policy. It covered claims inter alia resulting from the conduct of the healthcare services defined in the policy schedule as the provision of medical services and treatment, including psychologists and counsellors. A prisoner who suffered chronic schizophrenia threw himself off a landing, was seriously injured. He sued GEO on the basis that they ought to have known of his medical condition and that they ought therefore to have provided him with access to psychological care and to counselling. That they had failed to properly assess him on his arrival and induction into the prison environment. The insurer denied indemnity on the basis that GEO had never at any stage examined this inmate, nor had they contemplated providing services, so there could not be a professional failure. No service had been provided because none had ever been contemplated. The argument of GEO is that as it was contractually obliged to provide psychological and counselling services, that should be covered under the policy as an omission. It was held in first instance that the policy did respond. On appeal to the New South Wales Court of Appeal, that decision was affirmed. The failure of GEO, in the opinion of the court, to apply its processes exposed it to liability, and that liability was related directly to the provision, or in this case, omission, to provide appropriate psychological and counselling services which exposed the medical malpractice insurer. Naidu and Brisbane Waters Private Hospital, another very recent case. Naidu was admitted to the hospital after becoming suicidal and was assigned to a psychiatrist, Dr. Grund. Fabulous name for a psychiatrist, that. During her stay, she reported sleep disturbance due to pain and tiredness, so was given a mixture of psychoactive drugs. Excuse me. The doctors had concern about chronic pain and depression. On examination, she was found to be overly sedated and suffering from insomnia. This continued throughout her stay. Despite this, the psychiatrist treating her, Dr. Grund, gave her permission to drive a motor car. She had 2 very short trips whilst an inmate at the hospital. She was readied for discharge. At that stage, the psychiatrist formed the view that this woman was capable of differentiating those periods of time where she should drive and those, or could drive, and those where she should not. On the day of discharge, she fell asleep. So instead of being discharged at 10 o'clock in the morning, standard discharge time, she was discharged at 2:30 in the afternoon. At that stage, the hospital provided for her some OxyContin, some Endone, and her car keys. Who would have thought that Endone and car keys don't mix? The mind boggles. She fell asleep, blacked out, had an accident, fortunately only suffered relatively minor injuries, but sufficient enough for her to mount legal action against the hospital and the psychiatrist. In the New South Wales District Court, Justice Wilson entered judgment for the plaintiff, apportioned 1/3 against the hospital, 2/3 against the psychiatrist, giving proof to the point that David made most eloquently about matters such as this invariably involving allocations of liability. The judge was critical of the hospital's argument that its only duty of care was owed in respect of treatment, and that their duty of care did not extend in any way, shape or form to transportation. He found that it was a matter of common sense, as I think we'd all agree, that she should not have been allowed to drive. The breach of duty on the part of the psychiatrist was so blatant, so very obvious, that peer evidence that he had not acted inappropriately was thoroughly rejected. In the judge's view, peer professional opinions could simply not be made out. Finally, AB in the Australian Capital Territory, the plaintiff was a young woman, AB, admitted to a public hospital overnight. Subsequent to her admission, another patient, Mr. Southwell, was admitted in a very aggressive, agitated and drunken state. He had a well-earned reputation for being admitted in that shape. During the night, Southwell sexually and physically abused AB, who suffered significant post-traumatic stress disorder. She mounted an action against the hospital for breach of its duty of care. The hospital's defence was that financial impecunity prevented it from doing everything that it might wish to do in respect of patient safety, but it was constrained by financial resources. That simply was a statement made by the hospital. It adduced no evidence that would have allowed any court to conclude that that was the case. And one wonders, even if they had, whether that would have been accepted as a viable defence. I doubt it. The court was not at all convinced. An amount of $250,000 was awarded in damages. This was, of course, a quite extreme case. There's a consistent thread in those three cases. It's of course that of mental illness, and in so many areas of insurance, not least travel contemporarily, that is a problem that continues to vex us all. So what are the major issues that I see for brokers? Well, I've said this before at seminars, medical indemnity is difficult. It's difficult to break the inertia, to break the clubbiness that adheres to the MDO insurers. But if you can identify some surgeons in particular, particularly cosmetic surgeons, given that each of them pays around $200,000, $220,000 a year, if you can get into your medical clients and persuade them to seek an alternative, you do now have, through TIGO, a very viable alternative. Viable both on price, no issues on cover, because this is a highly regulated area. Keep in mind that doctors enjoy massive financial support, and if you like, strategic support from the Commonwealth. They have the Blue Sky Claims Scheme, so $20 million, whether individually or in aggregate over a year. Beyond that level, the Commonwealth meets it. They have the Premium Support Scheme, so that specialists, if their costs exceed 10% of their billings, are supported by the Commonwealth. They have the High Cost Claims Scheme. At the moment, 50% of all claims above $300,000, shortly to move to $500,000, are paid for by the Commonwealth. They come out of the taxpayer's wallet. Tony Abbott laid down on his back, spread his legs and opened his wallet, more particularly our wallets, for the enjoyment of medical practitioners. Keep in mind that at all times there is a truism, the difference between God and a doctor. God doesn't think she's a doctor. Professional associations, if you're going to look at them, require the development of significant expertise in the clinical underpinnings of those practices, of those practice areas. If you are going to venture into it, be aware that you need to be very, very transactionally smart. You need to have a significant investment in processing, in systematising the procedures and the purchase arrangements around professional associations. The rewards are great. If you lose one, having had it for a few years, the risks are high. Allied health remains the most accessible segment. Difficult areas to keep in mind when you're addressing the area are boundary transgressions. Sexual boundary transgression tends to be the focus, but there are also a number of other areas of boundary transgression, not least of which is financial. A financial relationship between a treating professional, whether that professional is a psychologist, a physiotherapist, a dentist or a doctor, are unfortunately abundant, and they involve significant boundary transgression. Known circumstances continue to be a problem. So if you're arranging cover, if you have clients in this area, particularly new clients, then obviously you need to be assiduous in taking the history and in documenting the history and in having your potential clients sign off on that history. The final area of difficulty that may arise is in relation to runoff. Now, the chart that David showed you about the regulation of allied health professionals invariably made mention of compulsory runoff requirements. Because those are compulsory, they tend to be automatic in policies. Because the need for runoff cover is so enormous, there do tend to be a number of policies that have automatic runoff provisions. But to activate those runoff provisions is critical. Most of them require activation. So make sure that you understand those areas where runoff may be automatic but must be activated, as opposed to those areas where runoff is automatic and is automatically provided, so that you don't fall down on those.